Hello, and welcome back to Music 110. Today we're going to be discussing the Greats writing assignment, which is a short research paper that is due to be turned in onto Brightspace by midnight Sunday this week. So I want to go over the prompt of the assignment and then cover all of the important information that will be valuable to you when you put this research paper together. So let's take a look at the prompt. So this is what you're being asked to do. It says, using your knowledge of analog signal flow, digital file types and transmission, record a sound source and use it to create a stereo master mix. So in other words, go through the process that we've gone through multiple times in multiple assignments, but you're being asked to record something, put it into a digital audio workstation, and then create a digital file that is the sum of the stereo master mix. Once you've done that, in writing, describe how you would convert this mixed audio, the file that you just created, into a digital file format appropriate for several uses, including uncompressed professional level audio files, compact disc, music posting websites such as SoundCloud, and email dissemination. So in other words, right, you create this stereo master mix, and now you can make different versions of it for different purposes. So you're going to describe how you would convert the stereo master mix into different file types. And then you'll answer this. What are the limitations of each way of presenting and or distributing digital audio that determines the format, i.e. like the file size and type, that must be used? So for each of these uses that are listed under the describe point, you need to answer this question. What are the limitations of each, and what would be the appropriate file type for that particular use or purpose? So if you're going to take your stereo master mix and create different versions of it, why would you create different versions of it? And you need to connect that why to the different types of distribution or dissemination that you could choose. Use and cite appropriate academic resources to support your description. So you need evidence. You need to back up your reasoning for why, for example, you would use a particular audio file format for compact disc, but a different one for SoundCloud. So you'll explain why, and then you'll cite a source, an appropriate academic source. Then you're being asked to describe the ethical use of digital audio in a way that emphasizes the value of intellectual property. Consider that exact copies of audio files can be made, enabling unscrupulous people to distribute music without crediting its creator. So the last bit, we're going to be you're being asked to address intellectual property, copyright, in relation to the issues that you brought up earlier in your research paper, where you're talking about converting digital audio into different formats. So this research paper should be 2 to 3 pages typed. It should include a works cited page with all of your academic sources, cited in MLA style. You need at least 2 academically appropriate sources. And then down here, there is a link to the CCBC Library Research Guide that will look at later in this lecture. Okay, so this is what you're being asked to do. It's a short research paper. You are making a research paper where you're making an argument about which file types are appropriate for various ways to disseminate or distribute audio. So what do we need to do to get you ready for this? Well, if we're just kind of looking at the prompt, there are 3 important things to do today. 1, we need to review audio file formats because that's sort of central to what you're being asked, connecting particular audio file formats to particular types of distribution. We also need to learn about intellectual property. So after we review audio file formats, we'll be looking at the history of copyright in the United States and how that applies to digital music dissemination. After that, we're going to start looking for academically appropriate sources using the CCBC website so that you feel prepared to find those sources on your own. So this is what we're going to be doing today. Let's get started. Okay, so this is review. This goes all the way back to earlier in the semester when we were just getting started thinking about digital audio. Now, as a reminder, when analog audio is converted into digital audio, we have a continuous stream of information that's turned into a discontinuous sequence of samples. So when you make a recording of continuous sound in the air, if you make a recording on your phone, say, your phone is automatically converting the wiggles in the air back and forth into a very rapid sequence of measurements that's turned into digital data, into bits. So here, just as this is all review. So here we see the wiggle back and forth of the air, which is sound, which then gets measured by an analog to digital converter, converts it into a discrete sequence of measurements that we call samples. Then it is going to convert those measurements back into electrical energy that can push a speaker or some headphones, so that the speaker or the headphones wiggle relatively in the same way that the air was wriggling when you recorded it. Now, that conversion from analog to digital, there are a bunch of different ways to do it. And the ways to do it, you can think of those ways as different types of file formats. So different audio file formats are going to be encoding the information, which is the sound, which is the wiggles in the air, in different ways. And audio file formats, one way to categorize them, there are many of them, right? MP3s, waves, AIFFs, FLAC files, OGG files. It goes on and on and on. There are many, many audio file formats. All of those audio file formats, one way to categorize them is into whether they are lossy or lossless. So a lossy audio file is a compressed audio file. And what happens, this is like an example, for example, an MP3. When the information is taken in, there is a algorithm that sort of smooths out the waveform in a predictive way in order to decrease the amount of information that's in the file. So the algorithm mathematically goes through and sort of makes predictive decisions, and it dramatically reduces the file size because you don't. It sort of removes a lot of the what the algorithm determines is less important information, and can reduce the file size of the audio file by as much as 90%. A lossless audio file, no information is discarded. So once the information gets into the audio to digital converter, there's no extra step that reduces the amount of information. It's just the pure whatever you're getting from the conversion. So, of course, it's going to be a larger file. There's just going to be more information in it. The last category sort of combines the two, and this last category, lossless compression, really relates to internet streaming technologies. So what this does is it sort of kind of does a best of both worlds combination, where on one end you have a lossless audio file that is compressed for streaming purposes, but on the other end it is uncompressed through an algorithmic process. So this would be what, to get high quality audio over a streaming website, the streaming website will be using lossless compression. So when we're talking about a lossy file format like an MP3, why this is important is because it helps to reduce the bit rate that as the bits are being transferred over a network. So if the MP3 is a higher bit rate, it's going to there's more information to transfer over the network, and therefore it will transfer slightly slower. All of these when we're looking at all of these files and thinking about what is the appropriate file for the distribution type, we're always balancing accessibility versus delivery. Okay, so here's just to sort of review everything in terms of file formats. So we're always kind of doing this dance between fidelity, in other words, like high fidelity, something that is as close to possible as the original recording, versus storage. Certain distribution methods may require you to sacrifice fidelity in favor of a smaller file size. Other distribution methods will allow you to transfer larger sets of data, and therefore you would have higher fidelity. And certain distribution methods preserve the original fidelity of your auto recording, but are very data expensive. Large files that take that take much longer to stream and download and take much more server space. So the reason I have this review here is that when you're thinking about a particular audio file format, this is your logic to connect the format to the distribution method. So you want to maximize the fidelity, but certain distribution methods have limits on how much storage there is. And that storage could either be how much space you have on a hard drive, but you can also think of storage in terms of how information is being transmitted over a network. So if a network, and what I mean by that is like sending something over the internet. If a network can block together bits of information to a certain size, that we're still thinking in terms of storage. And what I mean by that is that when we are transferring data over a network, a computer will group it together into blocks. So, higher fidelity requires higher storage, and different distribution methods have limits on how much storage is allowed. Great. So that takes us through the review of the audio file formats. Let's move on to talking about copyright. So this is the last component of this covers the last component of what you're being prompted to write about in your research paper. And what I'll be talking about is copyright. We're going to look at we're going to define it. We're going to look at the history of it in the United States, and then we're going to connect this back to audio and music and what this means for how we distribute audio on the internet and what it means for the music industry. So, copyright. What is it? A copyright is a type of intellectual property that gives its owner the exclusive legal right to copy, distribute, adapt, display, and perform a creative work, usually for a limited time. So copyright is a type of intellectual property, and along with that intellectual property comes rights. Either it is going to be a right to copy, distribute it, to do that, or it could be a right against someone else. So if I have a copyright on some intellectual property, that gives me the right to do all of these things: copy, distribute, adapt, display. But it also gives me the right against you to do those things, right? So the creative work may be in a literary, artistic, educational, or musical form. Copyright is intended to protect the original expression of an idea in the form of a creative work, but not the idea itself. So copyright protects the expression, not the idea. That's an important thing to remember. A copyright is subject to limitations based on public interest considerations, such as the fair use doctrine in the United States. So we're going to cover fair use in just a little bit. So there are limitations on copyright. And again, copyright protects expression, but not the idea itself. Okay, so to start, so what is copyright not? Copyright is not the public domain. So when we talk about the public domain, we're talking about creative works that are not copyrightable. And what that means is that nobody has a right against us for to use that work. So the public domain consists of all the creative work to which no exclusive intellectual property rights apply. Those rights may have expired, been forfeited, expressly waived, or may be inapplicable. Because no one holds the exclusive rights, anyone can legally use or reference those works without permission. Okay, so here we're adding a new important term in how we understand intellectual property, which is permission. So if we go back to the scenario where I have a copyright on some intellectual property, that gives me the right to reproduce it, and it gives me the right against you to reproduce it. In other words, if you reproduce my intellectual property without my permission, I can sue you. You could ask for my permission, and usually that will involve an agreement of how much you're going to pay me to use my intellectual property, right? Now, when we're thinking about public domain, these are creative works that are not considered legally to be intellectual property. And that means that if you or I could use any of these public domain works without permission and without giving attribution to whoever produced it, whoever created it. So now that we've kind of got our two very, like, the fundamental sort of concepts of intellectual property as it's legally defined in the United States. So we have copyrighted stuff, which is property, and we have public domain stuff, which is not property. It's everyone's. So let's take a quick look at the history of copyright law in the United States. So what we see here is the original copyright law written in 1790. It is 2 pages long, and it establishes the basic legal foundation for copyright in the United States. What the Copyright Act of 1790 covered was books, maps, and charts. That's it. Those are the things, that's the intellectual property or the creative works that could be copyrighted. And what it laid out as far as the law is a book, a map, or a chart could be copyrighted for 14 years. That was the limit. The author could apply for another extension, which would be a 14-year extension, but that was it. So those are the only types of creative works that were covered, and that was the limitation on how long copyright lasted. So typically, after 14 years, what did it become? Public domain. Nobody had to ask for permission. It was usable by anyone in the society. Later, historically speaking, we get a sequence of new copyright acts that build upon, update the copyright acts that came before them. So in 1831, there's a copyright act that adds music compositions to the list of types of intellectual property that could be copyrighted, and it extends the term of copyright from 14 years, so doubles it to 28 years. A little bit later, the Copyright Act of 1870 adds trademarks and visual works to the list of types of creative work that could be copyrighted. In 1909, we extend the renewal to if you apply for a renewal or an extension, that gets extended to 28 years. And then things start to get a little crazy. So in 1976, the next Copyright Act extends the term of the copyright to the life of the author plus 50 years. This is also the point when, in law, we codify the concept of fair use, which we're going to cover in just a second. So about 20 years later, the Sonny Bono Act, which is another copyright act, extends the term of copyright to the life of the author plus 70 years, and for works of corporate authorship to 120 years. And you can kind of see a pattern here, right? Over time, each Copyright Act is extending the term. In 1998, we also had the Digital Millennium Copyright Act, which, if you were to compare it to the original Copyright Act of 1790, the original Copyright Act of 1790 is 2 pages long. The Digital Millennium Copyright Act ended up being, it's like multiple books. And what they were trying to do is come up with a modernized approach to copyright in the era of the internet. The most recent Copyright Act is the Music Modernization Act of 2018, which is a legal response to the development of online streaming services. and is an attempt to overhaul how songwriters receive royalties from digital streaming services. So we're going to talk about that at the end of this lecture. Let's first discuss this history. And one question that you might be asking is, what's up with this just constant extending the term of copyright from one Copyright Act to the next? So here we're looking at this graph, and what you see in front of you is how over time the duration of the copyright term in years is just consistently going up, right? Like consistently extending and expanding. And what a lot of people have called this this trend, this constant growing of or extending of the term of copyright, people have called it the Mickey Mouse curve. So here we are looking at a copyrighted image of Mickey Mouse. And here's the reason we call it the Mickey Mouse curve. So Mickey Mouse is created by Walt Disney in 1928. And from that moment forward, the Disney Corporation was lobbying the government to make sure that they could extend their copyright on the image, on the copyright of Mickey Mouse. And this led up to they were continually extending the copyright up until last year, when if we think about the term of the copyright now, we've gotten beyond the 70 years since we've got 70 years plus the extension, plus beyond the life of the author. And this is true, right? Because we know this is true because we know that the Disney Corporation was lobbying the government to write new copyright acts so that they could extend their copyright, their copyright over the intellectual property of Mickey Mouse. So one of the things that's driving these legal changes, is the interests of corporations to extend their privileges over intellectual property as long as they can possibly do it. So what does that mean for the public domain? So like I said, the public domain is intellectual property, is not really intellectual property. It's the other types of creative work that are not restricted by copyright. So here we have a flow chart that helps us to understand what the successive extension of the term of copyright through these copyright laws means for what works fall into the public domain. And if you look at this carefully, you can see how not only over time, as these copyrights continue to extend the term of copyright, they also make the works that were created within that era that that particular Copyright Act covered. The question as to whether it's public domain or not becomes increasingly complicated. Right? Because before the Copyright Acts that started to indefinitely extend the term of copyright, basically, it's like, was the work written before 1922? Okay, it's in public domain. But this becomes more and more complicated the more that these acts increase the sort of the number of stipulations possible. Okay, so we've covered public domain. We've covered the history of copyright and how, if you look at the American history of copyright, we have this kind of especially over the 20th century, corporations lobbying to extend the term of copyright as long as they possibly can. Now, there is another category of use of creative works, and this is the Fair Use Clause of the Copyright Act of 1947. And what this covers is ways that you can use copyrighted creative works, or intellectual property, without permission. So there are particular uses that are legal. So you can use copyrighted work without paying or getting permission from the owner of the copyright. So this is what the Act of 1947 says. The fair use of a copyrighted work, including such use by reproduction in copies or phonorecords, or by any other means specified by that section, for the purposes such as criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, or research, is not an infringement of copyright. Okay, so the things that I just listed, criticism, comment, reporting, teaching, scholarship, research, do not infringe on copyright. You're not required to get permission. But it's not quite as simple as that. So in determining whether the use made of a work in a particular case is a fair use, the factors to be considered shall include. So in order to really prove that in fact this is fair use, you need to prove these four things. The purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit education purposes. So 1, to prove that your use of copyrighted material is fair use, you need to prove that you're not making money off of it. And it is for some sort of nonprofit or educational purpose. 2, the nature of the copyrighted work itself. 3, the amount of substantiality of the portion used in relation to the copyrighted work as a whole. 4, the effect of the use upon the potential market or value of the copyrighted work. The fact that the work is unpublished shall not itself bar a finding of fair use if such finding is made upon consideration of all these above factors. So in other words, if there is a lawsuit over whether a particular use of copyrighted work is fair use or not, the lawyers will be making arguments that address each of these four factors. So did the person who used the copyrighted work make any profit? What is the copyrighted work? How much of the copyrighted work did the person who's using it, how much, like percentage-wise of the whole work, did they use? And did this use of the copyrighted work threaten the profitability of the copyrighted work itself? So all of those factors come in. It's not, and what is important to point out here, if we're reading the Copyright Act of 1947, is that in order to make these determinations, there are going to be arguments in a court. And a judge is going to have to weigh all of these factors as the judge listens to lawyers who are representing the copyright holder and the person who used the copyrighted material and is arguing that they in fact used it fairly. So let's look at a case study, and actually a good case study we've already listened to in this class. So John Oswald's dab that we listened to back when we were looking at splicing techniques, when he released that, it actually got him into legal trouble with Michael Jackson. And here's what happened. So John Oswald made this recording of dab. He did not sell it. He gave it away for free to libraries, uh, radio stations, other artists. So he made several hundred copies of it and started just sending it around to people. But he did not make any money off of it. So if we think back to the four factors that to make a work be considered fair use, he checked off number one. Now, he thought that he was that he was doing something that was legal, and he was sent a cease and desist letter from the Canadian recording industry. Oswald is a Canadian man, on behalf of Sony Records, who signed that, and Sony Records was who Michael Jackson was signed to. And eventually, they settled out of court, and the agreement was that John Oswald would destroy the remaining copies that he had and the master tape to dab. Now you might be wondering, then the next thing would be like, well, how were we able to hear it? Well, there were plenty of recordings that already were out in the world, and it was impossible for him to track them all down. So the versions of dab that we hear are the ones that sort of got away, so to speak. So here is Oswald writing 4 years before he made dab, and the reason I want to bring this quote in is because this demonstrates how Oswald himself was a student of copyright law and was thinking a lot about copyright law and the tension between the development of new recording technologies and old copyright laws. And so think about that as I'm reading through this quote. Musical instruments produce sounds. Composers produce music. Musical instruments reproduce music. Tape recorders, radios, disc players, etc. reproduce sound. A device such as a wind-up music box produces sound and reproduces music. A phonograph in the hands of a hip-hop scratch artist who plays a record like an electronic washboard with a phonographic needle as a plectrum produces sounds which are unique and not reproduced. The record player becomes the musical instrument. A sampler, in essence a recording, transforming instrument, is simultaneously a documenting device and a creative device. In effect, reducing the distinction manifested by copyright. Okay, so when he says that a sampler, and that's what he's using to create dab, is both a documenting device and a creative device, and then he says that is reducing the distinction manifested in copyright, the distinction between creative work and reproduced work, right? Derivative work. So musical language, he later in this essay, he says, musical language has an extensive repertoire of punctuation devices, but nothing equivalent to literature's quotation marks. Jazz musicians do not wiggle their fingers of each hand in the air, as lecturers often do when cross-referencing during their extemporizations, because on most instruments, this would present some technical difficulties, plummeting trumpets and such. Without a quotation system, well-intended correspondences can be distinguished from plagiarism and without a quotation system, well-intended correspondences cannot be distinguished from plagiarism and fraud. But anyway, the quoting of notes is but a small and insignificant portion of common appropriation. Okay, so he's making the case that what he is doing in his works is like what an academic does when they quote another author, putting authors into new conversations and new contexts. And he's making the argument here that this should be considered fair use. Why? Well, you can see he's really kind of emphasizing that this is for educational nonprofit purposes, for the like conversations that would happen in culture. So, what can we learn about this case study? Well, one, copyright is enforced by litigation. So, the reason that the tapes, John Oswald's tapes, were destroyed was because lawyers that were representing Sony and Michael Jackson sent a cease and desist letter. So this is an important thing to think about in terms of copyright. Like, it's a law, but unlike some other laws, there is no police force that enforces copyright. The way that copyright is enforced is lawyers that represent the copyright holder. Then they will bring the case to court. But it's not like there are copyright police. There are in this, when we think of something like YouTube, there are in the sense that YouTube is being asked by the government to enforce restrictions on the type of content that they are hosting. But again, that isn't the same as a dedicated police force that is going around looking for copyright infringement. So the way that it is enforced is through lawsuits. Secondly, the challenges in mounting a fair use legal defense. Now, John Oswald is still convinced that what he was doing was fair use, but of course, Michael Jackson and Sony Records have more lawyers and way more money to mount a legal defense. So his calculation was, all right, I will cease and desist. Third, new technologies present challenges to establish copyright law. Now, that is, that's demonstrated in this case study when we think about, like, even though they got him to cease and desist, even though they, when I say they, I mean the lawyers for Sony, were able to destroy all of the copies that he had left of this song and the master tape, the song still exists. It's still out there. And a huge reason for that is people were able to reproduce it themselves, both through analog technologies and digital technologies, but also that with these new techniques, like what John Oswald is arguing, a lot of these new technologies allow us to quote and recombine copyrighted materials in new ways that previous copyright laws may not have like a logic to cover, to deal with. Okay, so that kind of takes us through the not always, maybe the murky waters of fair use. So in order for the argument to be made that something was fair use, you have to hit each of those four categories, and some of them are a little bit more ambiguous than others. So we've covered copyrighted, one type of intellectual property, which is copyright. We've covered the type of creative works that are nobody's property, which is public domain. We've covered the fair use of copyrighted material, i.e., it is fair to use it without permission if you meet the 4 criteria listed in the Copyright Act of 1947. Now we're kind of getting up to the modern era and new concepts of intellectual property that are designed in response to um, internet technologies and like new ways of sharing information. And what we're going to be covering next is the Creative Commons. So the Creative Commons, actually, we are all really familiar with because the sound sources that we were using from freesound.org are all uploaded with some type of Creative Commons license. So what are Creative Commons licenses? A Creative Commons license is one of several public copyright licenses that enable the free distribution of an otherwise copyrighted work. A Creative Commons license is used when an author wants to give other people the right to share, use, and build upon a work that the author has created. Creative Commons provides an author flexibility. For example, they might choose to allow only non-commercial uses of a given work, and protects the people who use or redistribute an author's work from concerns of copyright infringement as long as they abide by the conditions that are specified in the license by which the author distributes the work. So, Creative Commons license is not public domain, right? Like, this is a way of copyrighting a creative work. In other words, it has rights associated with it, attached to it. So it's not the public domain. But it is different than copyright because whereas copyright gives the holder of the copyright exclusive right to reproduce and disseminate the work, Creative Commons licenses create a more robust set of rights that are attributed to the author, but also to the people who the author shares the work with. So the creator of the property, if it's covered by the Creative Commons rather than copyright, along with it are certain things certain stipulations that you must follow if you use the copyrighted work under the Creative Commons license. So when we were looking at Freesound, many of them would have a Creative Commons license that might say share and share alike, or you must attribute the author, the original author. You can use it, but you have to cite me. There are a whole number of Creative Commons licenses. So here is kind of the spectrum of Creative Commons licenses that goes from the most open to the most restrictive. So, and these are the types of Creative Commons licenses that you can attach to your own creative work. So we go from public domain dedication, where you would say, even though this was created in the year 2024, meaning that under copyright law, it would automatically have a copyright connected to me for my entire life. This is saying I'm putting it directly into the public domain. And then we can go all the way to the most restrictive, which would be, my intellectual property. You can copy it and distribute it and display it, but you cannot do it for any commercial, you can't make profit off of it. So we don't need to go through the nitty-gritty of each of these licenses. What's important here for us to notice is that this is a way that creators are responding to new ways of distributing their work on the internet and the ways that internet collaboration, uh, the types of collaborations and ways to collaborate on the internet that people started to innovate on the internet. We see people saying the standard uh, 19th century uh, copyright legal regime is not really set up for the reality of internet, how ideas are exchanged on the internet. And so they come up with a whole variety of ways that you can share your creative work on the internet and have more control over, well, what does that mean to share my creative work? So when people are attaching Creative Commons licenses to their work, they're able to have more control over it, not just in terms of property, but in terms of how they are relating to other people online. So what does this leave us with? We have a spectrum of rights. When we're thinking about intellectual property. So we can think about copyright as all rights reserved. Whoever holds the copyright to an idea, to a a creative work, they have all of the rights reserved to them, to the copyright holder. So permission is required. Creative Commons, we have some rights reserved. And it sort of depends on the license, like we were just looking at on the last slide. But globally, when we're thinking about all of the Creative Commons licenses, reuse is permitted without permission under the specifications shared in the license. So you can use this without asking for my individual permission, as long as you also do whatever these things are that I require. Of course, if you do not follow those things, then you're infringing on my rights, right? Like all the way over to, in the public domain, no rights reserved. So it can be used without getting anyone's permission. So when we're thinking about intellectual property, we have to be thinking about, well, what are the permissions that are associated with this particular creative work? Do I need to get permission? If I don't need to get permission, are there certain things, certain specifications that I need to follow, or is there just no permission required? All right, so that gives us the whole range of it. Now, and this can give us a sense of like, well, what is legal, what is illegal when it comes to using other people's creative work. So we can figure out, like, am I breaking the law or not? Copyright is also important for how it structures the flow of money in the music industry. So here we're looking at a graph that is looking at total music sales over the past 50 or so years. And so you can kind of see the ebb and flow of total sales that the music industry is reporting. So revenue. And this is why the reason that copyright is important in understanding the larger trends in the music industry is, along with copyright comes, the right to reproduce and distribute. And if you own that copyright, that means that you can make requirements on people who do not own it. And those requirements would be, pay me. So what we see here is the music industry over the last about 10 years has seen an incredible increase in revenue. And the increase in revenue is driven mostly by streaming. And to a lesser degree, vinyl records are making a comeback as a medium. But really, we're looking at paid streaming and ad supported streaming is the engine that's driving the resurgence of the music industry. So this means we've got new technology, new reproduction and distribution technology, and lots of money that is being generated and moved around using these technologies. So with streaming technology, we need to think about how copyright fits in to or helps to determine who's getting all this money. So where is this money going when we see this huge growth in the music industry over the last 10 years? Where is all that money going? It's going into streaming, but what does that mean for all of the factors in the production of music? So what we're looking at here is a chart that gives you a sense of the reality for performers, for musicians, for artists, in terms of getting money through streaming. So this compares the sort of main streaming platforms, and what you see is that one, like the amount of money that you receive per play of your music. So every time a song that you wrote, how much money are you getting? And it's well less than a cent for every streaming platform. We also see on the far right that in order to make minimum wage, the artist would need to total a certain number of plays of a song per month. So if you wanted to make minimum wage and your songs were on Spotify, you would need people to play your song 366,000 times in order to make minimum wage that month. So you might be wondering, well, where's all the money going? Because the artists aren't getting very much, right? So where is all the money going? So copyright helps to determine where royalties go. And in the United States, there are the way the money is going to flow based on copyright is going to follow the sort of the path that you see on this graph. So the revenue that's coming in is going to go to the distributor, like in this case, Spotify, let's say. Then some of that money is going to go to the recording owner, which may be the artist, but is often the recording company. In the United States, there are several agencies that are tasked with collecting these royalties on behalf of artists. Here's another chart that's kind of giving us a more clear sense of numbers and the flow of royalties. This is based on what's happening in the UK, not in the US, but the systems are rather similar and the numbers are very close. So when you have the total revenue that's coming into Spotify, and that's going to be divided up between the record labels. Then the streaming service is going to get some of it, and then the royalties that go out to the songwriter and to the performers are going to be 15% of the total. So you get paid a little bit from your label. If you're an artist, you get paid a little bit from your label, and you get paid a little bit in royalties because you own a part of the copyright. But you're still getting less than 20% of the total from your work being streamed. And one of the major reasons for this is because these streaming services have their basic model is this. They look at total plays, and on the entire platform for a month. And then based on how much money they get in from subscribers, the inputs from people who are listening to Spotify, then they divide that up based on total plays that Spotify did for every artist. And then they figure. So if you are a major artist, if you're super famous, then you get paid out pretty well, because if you think about it like this, like let's say Spotify had, I'm just going to throw out easy numbers. So let's say in 1 month, Spotify had a total of 100 million plays. So that means if you are a major artist and 20 million of those plays were one of your songs, you would get paid out a percentage based on that 20% of the total, right? So Spotify is going to always take their 30% from everybody, and then they're going to distribute based on total plays of the entire catalog that's in Spotify. So that is going to benefit the major artists, the artists who are really big, and it's going to not benefit the smaller artists. There are other streaming websites that have more of that will connect, rather than paying artists out based on the total total listens from everybody. They determine it based on individual users. So, for example, if I am a fan of your work and I'm listening on one of these sites, what we're thinking about in terms of like a fan economy, and I pay a subscription of $10 a month, and let's say I listen to your track, that's the only thing I listen to that month. That would mean that because I paid it $10, that would mean all of my listening would go to you. So the streaming service would take their cut, but my the proportion of my $10 would go only to you. And it turns out that mathematically, that is better for smaller scale artists. So not the model that Spotify has, but something like the model that Bandcamp has. Okay, so let's review real quick. Copyright. 1. Copyright is a type of intellectual property that gives its owner the exclusive legal right to copy, distribute, adapt, display, and perform a creative work, usually for a limited time. And I'll add that exclusive legal right means that you can give permission to people to use it, but they must get permission from you. And typically, if they get permission, the reason they get permission is because they're going to pay you. The public domain, on the other hand, consists of all creative work to which no exclusive individual property rights apply. No permission required, no payment necessary. Fair use is the use of copyrighted work without permission for purposes such as criticism, comment, news reporting, teaching, scholarship, or research, and is not an infringement of copyright. Lastly, a Creative Commons license is one of several public copyright licenses that enable the free distribution of an otherwise copyrighted work. So those concepts will help you to answer the question on the prompt that is about the ethical use of intellectual property. So so the ethical use of digital audio is in a way that emphasizes the value of intellectual property. So what all of those slides will help you to do is to, one, define intellectual property. It will also help you to explain the ethical use of intellectual property, which will be contextual, right? Because if something is under a traditional copyright, there would be a certain sort of ethical considerations that you might not have to take if it's under a Creative Commons license. If it's under a Creative Commons license, you have to look at the stipulations. If the stipulations of the Creative Commons license are share and share alike, if you were to use that creative work, put it into your own, and then produce and then try to sell, to then create a copyrighted work where you have exclusive rights to that, that would not be ethical, right? Because you would not be sharing alike. Okay, so this takes us to the last section of the lecture today, which is discussing the how to find academically appropriate sources for this research paper. And if we go down to the section on Brightspace that connects you to the library website, let's just do that. So that'll take you to this page that that will connect you to academically appropriate sources for music production and audio recording. And if we go to audio technology, this is going to give you suggestions, places to start where you've got websites and also books. So let's see what we got here. Great. So over here, when we're looking at on the shelf at CCBC, here are some options for us to find academically appropriate sources that we can cite when we do our research paper. So I'm going to just click on one of these. Great. So this is the Principles of Modern Communications Technology. And if I click on view this ebook, it should take me to all right, so this will allow me to read this book within the library website. And one of the things I could do is just start putting search terms in, looking for important, using key terms to find the things that are important to me. So, for example, like maybe file format. And here I get a whole bunch of hits for file and format. Oftentimes looking at VHS or Betamax, which are video formats, not important for me, not for this paper. I'm not going to be talking about video formats, so maybe I will look for audio file format. Again, I'm seeing a lot of video results. I wonder if I put quotation marks around this, will give me the exact phrase. Okay, so um, I'm noticing that with this particular book, there is potentially some citable passages. However, this does seem, modern communications technology. It does seem a little more directed, more focused on video. But then I notice, part 1 is audio technology, part 2 is video technology. So rather than just doing a search within, because it seems to want to just go straight to the video results, I'm going to skip all the way to the index, and I'm going to see if I can find something like audio file format here. All right. Well, there's definitely a section on compact discs. I know that I need to talk about that in my research paper. Analog to digital conversion. I know I need to talk about that. All right. So there are some possibilities in this book I'm noticing. Let's see what are some other books available from this music production and audio recording page. I'm going to look over here. All right. So here we have modern recording techniques. This is a great source. However, when I click on this, it's the wrong link. So this should take us to an ebook for modern recording techniques, but instead it takes us to a ebook developing heritage, developing countries, Ethiopian nation building, which sounds super interesting, but it is not what I need for my research paper. So I noticed this. I did notice that this link is a bad link, and because of that, I included a PDF of modern recording techniques on Brightspace, so you can, and this is the PDF here, and you can search through this PDF for evidence to support your conclusions for your research paper. One last thing I'll say is that so here's a good place. The music production and audio recording portal on the on the CCBC library is a great starting place. You can also just go straight to the library, the main library page, and start searching for sources that might be useful to you. So maybe let's go internet ethics copyright music. Okay. I'm curious to see what that combination of terms will show up, will turn up for me. All right, already there's a lot of potential here in sources that are talking directly about copyright and ethics. One thing I'm noticing is that I'm seeing some periodicals turn up, and I'm seeing some books turn up, and I'm seeing some academic journals turn up. And one of the things for this research paper that you're being asked to do is find academically appropriate sources. Now, in general, I would say that let's try not to use periodicals. Let's try to use academic journals, because that means that these articles are going to be peer reviewed. So experts in the field would have been editors and would have put these articles through a much more rigorous process of testing and making sure that the knowledge is up to date. So what I did is I just went to source types and I clicked on academic journals, and this will guarantee me that I have peer reviewed academic sources that are um, that are going to be more reliable and more up to date. So, two ways to find sources. A good place to start would be the link that is in the prompt, but you can also just use the library website and uh, so manipulate your search results so that you're getting academic journals, and you can find sources that way. All right. Good luck writing the research paper, and of course, send me any questions you have over email. Rock on.